Ever wondered how disputes are resolved outside the courtroom in Illinois civil lawsuits? Two alternative dispute resolution methods, namely mediation and settlement conferences, are often employed to facilitate such resolutions. Mediation is a voluntary confidential process where a neutral third party, the mediator, aids the disputing parties to reach a mutually acceptable resolution. The mediator doesn't impose decisions but assists in effective communication, option exploration, and negotiation of a settlement agreement. Mediation sessions usually occur in a private setting, with the mediator employing various techniques to promote cooperation and compromise. If an agreement is reached, it's documented in a written agreement signed by both parties. However, if mediation doesn't lead to a settlement, litigation in court remains an option. On the other hand, a settlement conference is a court-ordered or court-facilitated meeting between the disputing parties and a judicial officer. Unlike mediation, attendance may be mandatory. The conference can occur at any stage of the litigation process, depending on court rules and the judge's discretion. The judicial officer's role here is to evaluate the strengths and weaknesses of each party's case, provide feedback on potential outcomes if the case were to proceed to trial, and encourage negotiation of a settlement. The officer may also offer insights or recommendations to help reach a resolution. If a settlement agreement is reached, it's documented and presented to the court for approval. If a settlement is not reached, the case continues through the normal litigation process. To sum it up, both mediation and settlement conferences provide parties in Illinois civil lawsuits a chance to resolve their disputes efficiently, cost-effectively, and with greater control over the outcome compared to traditional litigation. These methods foster cooperation, communication, and creative problem-solving, all while reducing the time, expense, and uncertainty associated with courtroom litigation. While it's hopeful that disputes can be resolved at this stage, preparation for trial remains a priority if a resolution is not reached. Coordinating dates for these processes involves several parties and schedules, but once a time, date, and location are set, you'll be notified and prepared accordingly.